Hey, good morning. Really? Oh, I've seen pictures of California. I know we all have. I've never seen snow that high. I mean, overland. Exactly. Well, that's where Donner Pass is, I think. Yeah. Oh, yeah.
Those trees, they were turning gray when the snow was 25 feet off the ground.
I was talking to Gabby the other day. She's got her first 2 appeals assigned. She said she was nervous. I said, call David, for Christ's sake. Just telling the process to get file or briefs reviewed like you had before.
Court, all rise, please. Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Singh. To my left is Judge Brennan. And together we are your panel on the three cases we're hearing this morning. Our first case is a SORB matter, 2022 P66, John Doe number 22164 versus Sex Offender Registry Board. I want to remind the parties that we have read the briefs and are familiar with the arguments and the facts, and I urge you to cut to the chase to the extent possible. That having been said, if you feel you've made your points, there is certainly no shame in sitting down. Counsel?
Good morning, Your Honor. Fred Burkholder on behalf of Doe 22164. With brevity in mind, I draw the court's attention to the Supreme Judicial Court's recent decision in Doe 7546. In that decision, first of all, the caption is 487 Mass 568. In that decision, they make a very important finding relevant to this case. And the finding is as follows. As the hearing examiner noted in her denial of Doe's motion, the regulations provide that Doe may seek reclassification 3 years after she is released. Why is that relevant to my case? My esteemed brother makes the argument that the board frequently makes in these cases, which is, you have reclassification available to you, why are you bothering us? My client did not have that remedy available to him. So what is the dilemma? And that's really why this case is important to me. This is not the only one that I have. You have individuals that, for whatever reason, don't get a chance to file a motion under 7083 to vacate a classification as premature, and then their release rapidly approaches. I had one of those very recently, where I was notified that the man was going to be released in a few days. I was able to put together a motion. And of course it was denied summarily because the individual was still in custody. One of the other bases. I appealed and took it to the Superior Court, and the Superior Court judge said, as I see it, we have a situation where the regulations require that classifications be based upon a current determination, but yet we have a bar to them filing when they're incarcerated, other than to make it provisional, which you're now out of time. Then they get released, and the most important 3 years of their life, when they're first hitting the street and trying to find some stability so that they can potentially get on with their life and not face further problems with their classification, they are barred. That's the first thing I want to raise.
Can we just test that a little bit? Is your client entitled to a new hearing now under the regulations?
Yes. Yes, he certainly is.
Why isn't that a better, not an equal, but a better course of action for him? The most he can win in the case before us is a new hearing.
Because of the following. Two things. First of all, I'm not certain to what degree the court is familiar with the reclassification process. It is not as streamlined as one would like it to believe. When an individual gets a final classification, they finally become eligible for the 3 years to have passed. They then, on their own, have to file a motion for a reclassification without the assistance of counsel. They then wait 5 or 6 months for a determination to be made on a pre-classification. They're sent that pre-classification determination. They're then offered the opportunity to either accept it or to request a hearing, and then, of course, to request counsel. Then the case gets transferred back to CPCS, and they have the opportunity to try to assign counsel. And whether the court is well aware or not, there are not a lot of us that do this work. As a result, the cases oftentimes sit for 2 or 3 months until someone has time to do it. My brother writes a lot of briefs. You know how many I write. I mean, there's just a ton of this work. Then once you get to that point, then you have the opportunity to request a hearing date. And when you do that, the hearing examiner's staff, God love them, they're great people. I work with them consistently. Always have to put these cases basically at the end because they have people that have to be classified before they're released from custody. So in all reality, what are we looking at? We're looking at 9 months to a year versus when you get a remand. I got a remand out of this court. I believe you were one of the justices on it. I was contacted and told I was going to do another hearing on that case, even though an expert was to be now allowed in 3 weeks. That's the first problem. The second problem is more of a fundamental problem, and that being this. In all my years of practice, which is now rapidly approaching 40, I have never seen anybody be denied more both the effective assistance of counsel, and most importantly is that beloved Judge Gantz wrote before his passing, this is different than a denial or ineffective assistance of counsel. This is a denial of counsel. His attorney didn't file a notice of appeal, so he lost his substantive rights completely. Based upon that, I'm asking this court to consider it a structural error and allow him the opportunity to have a hearing forthwith. Does it answer your question? To some degree it does, only because it sets the parameters. When you get that determination, then the hearing examiner is going to have to take a serious look at the miscarriage that resulted in it. Otherwise, what you're going to get is something happened 20 years ago, we don't have to worry about it. Something happened while he was incarcerated, we don't have to worry about it. In this particular individual's case, it's extremely important because but for that particular alleged unusual conduct, he hadn't had any sexual offense, and he's only had one that he's convicted of because the other two were considered there wasn't adequate evidence. He's only had one, and it's 20 years ago. So because of the manner in which this case was handled, this man has been on the street for 6 years with a level 3 classification, sustained 2 gunshot wounds as a result of that, and he basically, I'm sorry, excuse my French, got screwed by the legal system. He got no recourse whatsoever. And then when I filed my motion, what was the response from the hearing examiner? It was this: motion denied, period. Is that a real consideration of the miscarriage of whether there was a miscarriage of justice that Judge Gantz is asking for? The last thing I will say is this. This issue is not new to this court. It was recently visited in 108447. And in that particular case, in footnote 6, it says, Doe also requested this court adopt the criminal rule that prejudice is presumed when counsel's deficient performance effectively deprives the defendant of an appeal. And in this case, because the individual qualified for reclassification, because he alleged a medical condition which waives the 3-year requirement, they had a basis on which to say this is not an issue that we have to address. That's not present in my case. I'm asking this court to finally address that issue, follow Judge Gantz's wisdom, and say this is a structural situation, and give these individuals an opportunity to have an attorney who does what they're supposed to do. I have nothing further.
Thank you, counsel. We'll hear from the board.
If it pleases the court, David Chennai for the board. It's interesting, 7456, I actually edited that brief for the attorney for the board handling it, and my memory was that the Supreme Judicial Court was not really receptive to that portion of the argument that I created. So I'm not sure, I'm trying to remember what the ruling was on it, but the inference we got from the court was that 3 years is from the last hearing, not based on someone's release from incarceration. But more importantly, in this case, the board's position is that this individual hasn't been able to show, and I think the Superior Court was correct, that he suffered prejudice from the denial of his motion to vacate the initial classification. And again, as this court has recently stated, that the bar for reclassification is very low. In fact, I can tell you just about, I would say every single case, every single individual every 3 years is going through the reclassification process. So the board's position is that that the motion was denied properly, and that without more, the board would ask you to affirm the board's decision in this case.
Mr. Chennai, can I ask, is your experience the same as Attorney Burkholder's with respect to the 3 weeks on a remand and 9 months on a reclass?
I've had cases that have been quickly on remand. I've had other ones that have actually dragged on, especially when, depending on what the caseload is. And that's one of the problems the board has, is that its caseload is fluid in the sense that there'll be a number of people that we petition, and then we wait for CPCS to make appointments. So I can go months without MJPs, or Superior Court reviews or appeals, and then all of a sudden I get 10 at a time. So, there are periods of time when the board can get right to a case that's been remanded. There are other times it takes a little longer. There's other times where the board can get right on a reclassification. There's other times it takes longer. Again, it's dependent on a number of factors, but the appointment process for CPCS, and again, Attorney Burkholder's right, I think that there's a dearth of attorneys who are still taking these cases on the CPCS side, so they have to wait until they can get attorneys to do the cases. But again, we go through periods where there's a lapse between the hearings because they can't get attorneys, and then when there's that kind of lapse, all the other procedural processes such as judicial reviews and appeals also follow that same train. So,
Counsel, what do you have to say of the argument that you shouldn't have to show prejudice when you've been denied the entire appeal?
I think, the courts have been pretty clear on that, on the Poe versus the Sorb, which is, the whole idea of the prejudice someone gets when the board, or when there's a motion to vacate or a motion to dismiss that's denied, they have to show that they were prejudiced by it. That's just the law as it stands. I don't think changing it to a criminal status, because criminal cases, there's really two areas that where a person is entitled to more than just procedural due process, and that's criminal cases and where there's child removal cases. Other than that, all they're required to give is procedural due process, and under procedural due process, it is an idea of showing prejudice. The criminal cases and removing of children from their parents, because of the substantial rights involved in them, they don't have to argue the prejudice part. But we have to argue it in these cases because you're dealing with procedural due process, not substantive due process issues.
On the allegation of ineffective assistance at the hearing stage, I think your argument is that the issue about about Doe's conduct or with respect to a female staff member, that was just one of many factors that was considered.
Correct. I would say this. The hearing examiner, if you look at the decision, just lists that as one more of his disciplinary reports. The hearing examiner didn't say, oh, and by the way, because he had this incident with this woman that was reported in the DOC records, that I give extra weight to this, or I consider this separately. All the hearing examiner wrote was a list of the different disciplinary reports, and that was included in it. If this was the only disciplinary report he had, I think there's a stronger argument to say he was prejudiced by it. But in this case, taking that one out wouldn't have changed.
It's the only one that has some sort of a hint of the nature of a sexual nature. Isn't that right?
I've got a case later today. I'm trying to remember which one's which, but I think that is kind of what was inferred in it. But at the same time, the hearing examiner doesn't even mention it in the discussion section. It's not like the hearing examiner really gave much weight other than it was another issue that he had with all of his other issues between his two different incarcerations. And his other issues were pretty significant too. There's an incident where he pulls a knife on someone. There's an incident where he throws a hot coffee pot at someone. It wasn't like his inappropriate interaction, and again, it's not even described exactly what the inappropriate interaction was. And so the hearing examiner, I think, did a good job of just saying it's just one more incident on his record. And again, the affidavit he wanted to submit didn't really clear up that issue. All it says is he was transferred because he wasn't transferred in retaliation for bringing a civil suit, and that it mentioned that he was being transferred. It didn't specifically say that that he did not have an inappropriate interaction with this woman. And I think really if you read the full sentence of that DOR report, it also kind of indicates that that he was told not to have interaction with this woman, and he continued to do so. And I think that's where the problem lay for him. So I don't think, again, that that would have, in the issue of showing prejudice, that one incident, correcting that, would have changed the outcome of this classification, is essentially what the board's position is on that issue.
I think we get it.
Okay, I appreciate that.
Thank you, Mr. Chennai. Thank you both.
Thank you.
The case is submitted. Our second case of the morning is 2022 P836, Thomas J. Manning versus Michael D. Gargas. Mr. Manning, the floor is yours.
Good morning. My name is Tom Manning. I'm plaintiff appellant. I want to thank the court for the opportunity to speak this morning, but I will rest on my brief.
We still can ask questions. So in that vein, let's say hypothetically you were to prevail in this appeal, so the case goes back. What do you expect to gain from this suit under circumstances where we're talking about a very small estate, and it appears, reading slightly between the lines, that what was going on here was an intra-family dispute in terms of the care of your mother. Your sister had health care proxy, purported to exercise that, and you argue that, she had no reason to because your mother was still in sufficient shape to make her own decisions. The appointed personal representative looks into this and says, I'm not going to touch this. How do you expect to prevail were this case to go back?
I would expect to prevail on the accounting for the damages that resulted from my not being able to pursue a claim against the Aviv.
And you would have to show that you would prevail on that claim, right?
Yes.
And you believe you've done that in the briefing?
I believe that I will prevail in the lower court, that I will prevail that Aviv was liable, yes. I mean, I don't know that I needed to do that in the brief or here.
Sir, can I ask you, in your brief, you actually refer to Mr. Gargas as someone you agreed to appoint as an experienced personal representative.
Yes.
Can you talk to us a little bit about how you see it that he went beyond principally a private function as a personal representative of your mother's estate to a commercial transaction, as it were?
Well, the commercial transaction was I was a buyer of his services to perform executorship of my mother's estate, and I hired him on that basis.
Did you hire him, or was he appointed by the court?
Well, he was replaced. I was nominated by my mother. My petition was before the court, and I had my petition, the name withdrawn from that petition,
right,
and his name put on it with my agreement, if that's your question.
But
Okay.
was he on a court list? Was he appointed by the court?
I'm not sure that I could, we might talk past each other with the term appointed by the court. I petitioned the court to be executor of my mother's estate. Through an agreement amongst the beneficiaries, we agreed that my name would be replaced by Michael Gargas, so he effectively petitioned the court to be the executor of my mother's estate. After my name was taken out, his name was put on.
Is it fair to assume that that development was because the siblings could not get along in terms of how the estate was going to be administered?
There was a single major issue between the siblings as to how my performance as executor there was an issue there as to whether it had to do with seeking liability from Aviv in healthcare providers. They were concerned that I would pursue a claim against Aviv, and as a result of that issue, which was discussed in open court, I was offered to continue to be executor of my mother's estate at the probate hearing in October of 2016, if in fact I agreed to give up any claim or not pursue a claim against the healthcare providers.
So if that was the key issue at the time,
Yes.
this controversy was not a secret one. It was not hiding. This was what the parties were debating. If that's the case, how can it be that the claim can go forward now as opposed to something that should have been addressed many years ago now, one way or another?
Well, it couldn't have been addressed until there was someone appointed as executor. So in October of 2016, when we were, as a beneficiaries, debating who was going to continue as, who would be executor, there was no claim on the table at that time.
Okay, but then an experienced court administrator, someone who's experienced in being an administrator, was appointed apparently by agreement, and it's undisputed that you raised with Mr. Gargas the possibility of going after the healthcare providers. In fact, that was your issue at the time. And we know that Mr. Gargas decided not to do that. Why wasn't that the time for all this to be raised? And in fact, you did raise it in your objection to the final accounting, as I understand it.
No, I did not raise objection to his not pursuing a claim against Aviv in the final accounting. The issue put forward to Mr. Gargas was to investigate the claim. I brought the claim to him the first time I spoke with him, and he promised me that he would investigate the claim against Aviv. He came back to me and said that he did investigate it and declined to pursue it.
Suppose his investigation amounted to talking to your siblings and your sister in particular, and she says, well, I'm a healthcare proxy, I'm good with it, we're done. Is that not enough? Or do you think he has to actually engage in some sort of, well, I'll leave it at that.
Well, that would have been grossly inadequate, and I'll tell you why. A healthcare proxy exists on paper until the healthcare proxy is invoked. The key issue here is whether Aviv acted against my mother and kept her in their facility with granting powers to somebody whose healthcare proxy was not invoked. Whether my sister had the healthcare, I was a healthcare, I was the alternate healthcare proxy. The invocation of a healthcare proxy in Massachusetts requires major steps, very deliberative steps on the part of an attending physician that's overseeing my mother's care. That never happened. My mother's healthcare proxy was never invoked.
But what do you mean by the term invoked?
It means that my mother's liberties are taken away and they're given to her healthcare proxy to make decisions for her. That's the purpose of the separation of my mother names somebody in healthcare proxy.
I understand, but it's not a judicial process.
It's a
sort of like a mortgage foreclosure.
Well, it can be. Let me separate the two. There's a process whereby a physician, an attending physician, can invoke it with under circumstances of competency, has to also engage a geriatric psychiatrist, if in fact he or she is not skilled in geriatric psychiatry. But there are multiple steps. It has to be very well documented. My mother has to be communicated that. And even after my mother is communicated, if it did happen, which it didn't, if my mother overrode it, then it would have to go to the court. Okay, where the court, someone would have to seek a court order at that point to say, well, the healthcare proxy is invoked, but your mother doesn't agree with it, then it would go to the court. None of that ever happened.
So what would you have envisioned an appropriate investigation looking like?
It would have been very, very specific. Obtain the medical records of my mother's healthcare providers and look for the documentation or ask for the documentation of my mother's attending physician that invoked the whoever it is that invoked this healthcare proxy that was claimed.
You were pretty clear at the time that he didn't do that.
Very. I mean,
Okay.
that was.
So what was the surprise?
Let me back up. Not at the time. No, I'm sorry. At the time of my obtaining documents from him in 2021.
So, again, but at the time that you were having this conversation, and Mr. Gargas said, I'm not going to go there, did you ask him, well, did you get medical records? Did you speak to my mother's care providers? Did you do anything at all to see, when you're telling me, I think there's a great claim here and you're not going after it, can you tell me why, what you've done? Anything along those lines?
When I first brought the claim to him, we discussed all that. I told him that my mother's healthcare proxy wasn't invoked, that there were documentation. He had to acquire documentation. He had to look into this. He had to investigate the medical records. All of that was discussed. He promised me he would investigate the claim. He took 6 weeks, and I kept pushing him because I was obviously looking for an answer. He finally came back to me 6 weeks later and said that I investigated the claim and I declined to pursue a claim. Now, I did not ask him what steps he took at that point. We had discussed that previously. I told him what was important in order to really get to a point where we could decide, where he could decide whether it was appropriate to make a claim.
I'm looking in the record at the affidavit that you submitted
Yes.
trying to challenge the final accounting. And on the point of the claim against the healthcare provider, what you say is you're not challenging his failure to do it. It appears that you knew at this point he wasn't going to pursue it, because what you say is Gargas has been non-communicative as to how his final account petition impacts claims for the benefit of the estate that Tom is pursuing with healthcare providers and that Gargas is aware of. This appears to presuppose that you knew this wasn't going to be pursued, and therefore your objection is based on he hasn't told you what the impact is going to be on you after the estate is closed.
Your Honor, were you reading from an affidavit?
I'm reading from what you signed. This is from Record Appendix 74.
You mind if I look at that?
Sure. It's the affidavit in objection.
Page 74?
It's Record Appendix page 74.
So this is a question as to whether or not, how I would process monies that would be collected by me for what I was pursuing. I was pursuing claims with a nursing home facility, which I actually did collect, okay? And that is discussed further in the complaint and in the brief. But I was pursuing 3 different claims, 2 of which I collected on, and 1 of which continued, which was Aviv. And I was asking in this how it was that if he closed the estate, and again, being totally non-knowledgeable about estate proceedings, if the estate is closed or final account is made, how is it if I collect money under Chapter 230, Section 5, does that money get processed? How do I distribute it to the beneficiaries? How do I collect it, et cetera, et cetera? I was given no answer and no direction on that.
So are you saying paragraph 12 has nothing to do with the subject of the current appeal, or?
I'm not sure how it applies, Your Honor. It has to do with, it's not questioning whether or not something is being pursued. It's questioning, when I get money for what I pursue for the benefit of the estate, how do I process it? He was non-communicative on that.
But am I wrong that it was clear at this point that Mr. Gargas was not pursuing the claim that
Yes.
you wanted him to?
Yes, and he knew that I was pursuing it. There was agreement before the final account that I would pursue it.
Okay, your time is about expired anyway. Thank you very much, sir. We will
Thank you.
hear from Mr. Gargas's attorney.
Good morning, members of the panel, and may it please the court. I'm David McBride, and I represent Michael Gargas. We respectfully ask that the court affirm the decision of the Superior Court, which dismissed the 5 counts of Mr. Manning's complaint, and for the reasons stated in our brief and stated by Judge Liu in his decision. Specifically, as the court knows, all of the claims, all of the 5 claims, basically arise from the same issue, which is that Mr. Manning thought that a claim should be pursued against the assisted living facility where his mother had lived in the end of her life.
Well, I mean, his claim isn't that it should have been, that the claim should have been brought. His claim was that he thought that there was an investigation that was done. So the claim is the failure to do any sort of investigation.
Well, that is part of it, but he also claims in the complaint that he lost the money he would have received by that claim, had that claim been made. So I think it's specifically asking for the court, the breach of fiduciary duty is that he did not properly investigate the claim, and that Mr. Manning, in the words of the complaint, paragraph 37, the breach of fiduciary duty cost the loss of the value of the claim against Aviv.
As the measure of damages, presumably.
Yes, Your Honor.
So that if it wasn't a claim worth pursuing, even if there was a breach of fiduciary duty, there was no damages.
Yes.
Your argument.
Your Honor, and specifically as to each of the 5 counts, Judge Liu goes into some detail as to why they were each dismissed on a motion to dismiss. The first count for breach of fiduciary duty, he dismissed because the issue was precluded. As Your Honor, as Justice Milkey, you just covered, the issue was raised in the probate court proceedings by Mr. Manning. He wanted the matter pursued. Mr. Gargas declined to do so. And again, as the court has already referenced, Mr. Manning's 3 siblings were against this, and so the matter was not pursued. That was clear to Judge Kaplan when she made her decision affirming and approving the accounts by Mr. Gargas and settling the estate, concluding the estate.
Can we for a moment get back to Judge Brennan's question in terms of what would a reasonable investigation have looked like on the healthcare proxy issue?
You know, I think it would have determined Mr. Manning's claim, and what he told Mr. Gargas was that the claim included false imprisonment, that they were holding Mrs. Manning against her will. I think, in my view, an appropriate investigation would start with determining who the healthcare proxy was the healthcare proxy invoked? And I don't know the particulars, it's not in the record as to which doctor said it, but I know that the law requires that before the healthcare proxy is invoked, before the healthcare proxy can be operative, it has to be invoked. And in the Superior Court case that Judge Howe's decision in the record, it references the fact that it was in fact invoked. I think that Mr. Gargas's investigation would be, okay, was the woman incompetent to the point where the healthcare proxy would be invoked? If it was, did the appropriate healthcare proxy agree that she should be a patient here? And therefore, that would be the end of the investigation, in my view.
Wasn't ultimately, I thought that ultimately there was no documentation regarding that determination of a lack of competency and therefore having to invoke the proxy.
There's nothing in our record that specifically states that that was decided. But in the decision that is in the record, that one of the 4 other Superior Court cases that Mr. Manning has brought, there's a reference by Judge Howe that Mr. Gargas made his investigation by inquiring about this to the healthcare proxy, Mr. Manning's sister, and was told that she was properly invoked, appointed.
How could that be an adequate investigation? Because that is the claim, that she improperly asserted the proxy whenever she shouldn't have. So we have to get back to the issue of whether there's proper documentation. The claim is that there was a request for discovery at some later point, and specifically a request for documentation regarding this issue, and the response was, there's no such documentation.
Right, and I don't think, Your Honor, the fact that there was no documentation produced by Mr. Gargas means that he didn't do an appropriate investigation. I think his investigation would be sufficient were he to inquire from the family and from the appointed or invoked healthcare proxy how this came to be that Mrs. Manning was living in this facility, and was it, in fact, against the will of the healthcare proxy. And once it wasn't, I don't think there's a claim, not the type of claim that Mr. Manning was telling him he wanted to bring.
The inquiry go to the facility. The inquiry doesn't go to the family who all has a particular interest. It goes to the facility that has that responsibility regarding competency.
Right, but I believe that the fact that his sister was appointed or notified that the healthcare proxy had been invoked is testament to the fact that the facility physicians considered it to be invoked because she was incompetent, and Mr. Manning's siblings all agreed with that. So I don't think there would be much more that Mr. Gargas, as an administrator of an estate, could do beyond that investigation.
Even all that you've just discussed regarding this investigation, none of that is in the record. We don't know exactly what was done.
We don't. What we do know is that the healthcare proxy was invoked. We don't know why it was invoked or whether there was a decision made by which doctor. We don't know that, one way or the other. But I think an appropriate investigation to somebody appointed by the court to conclude this estate, when you have one of the beneficiaries saying to you, I think we have a claim against Aviv, the assisted living facility, would be to say, okay, let's see if we do. And once Mr. Gargas looked into that, seeing that a healthcare proxy had been invoked and that the proxy, Mr. Manning's sister, agreed with her other siblings that Mrs. Manning was to be cared for here, that would be the end of the investigation. It would be futile, I believe, for the estate to then go on and spend money pursuing that when the healthcare proxy who was invoked, who was appointed, doesn't want it, and the other siblings, the other beneficiaries, don't want it.
But the problem is we're viewing this on a motion to dismiss. So we're looking at the claim, and he's making a claim that in discovery, he received information, he received no documentation backing up this, backing up the claim that the healthcare proxy was properly invoked. So don't we have to look at that?
Well, I don't think the fact that there are no documents translates that there wasn't a proper investigation. It could be the investigation didn't require any documentation.
Sorry?
It could be that the investigation, as I've just described it, didn't require paper documentation to show it. It was documented by discussions with his sister. And again, Judge Howe's decision in the Superior Court, one of the other cases, references to the extent that that's part of our record and we can take note of it, it references that Mr. Manning told the court, the Superior Court, that once Mr. Gargas spoke to his sister and knew that she was the healthcare proxy and agreed with the care at Aviv, that was the end of his investigation. I think that's effectively what the investigation was. And I don't think anything more would be appropriate or warranted to spend more of the estate money doing something more than that.
To what extent can we look at those contextual factors. And by that I mean this was a small estate, and your client was hired to be the PR, and presumably there's something of a premium to conserve the assets of the estate and not, conduct a 2-week investigation that's not going to likely pay out. Again, can we take that context into account in this motion to dismiss context, or
Well,
no?
Your Honor, I think we can, to the extent that our record, which includes the documentation from the probate court, it includes Mr. Manning's affidavit in the probate court, it shows us now, looking at the record, that Mr. Manning was aware of this claim. He had voiced the claim. In fact, it had been the primary reason he said here today that he wasn't appointed the administrator or the personal representative of his mother's estate. So everybody knew about it going into that situation. Mr. Gargas was asked specifically by Mr. Manning to look into it. He did, or he told Mr. Manning he did, and he declined to pursue it. Now, yes, I think you can take into effect that you would likely have used up a significant portion of a relatively small estate pursuing a claim that, in Mr. Gargas's judgment, was likely to be unsuccessful. I think that is a reasonable thing to do. But, Your Honor, I also believe that under Chapter 230, Section 5, Mr. Manning had the right to pursue the claim that he is referencing, and he did. He says that one of the other 4 complaints in the Superior Court was dismissed because, and he references in the record, he was told that he had to have a lawyer to do it, and then wasn't able to get a lawyer. He blames that on Mr. Gargas, but I think that the facts don't support that. So to your question, Your Honor, I think it's entirely reasonable for Mr. Gargas to do an investigation, i.e. find out whether or not this claim would be valid, would be worthwhile pursuing. And I think the investigation, his own investigation, showed that it wasn't. He didn't. The other family members didn't want to pursue it, including the health care proxy. And everybody knew that and Mr. Manning said again today, he was going to pursue it himself. So now you have, well, okay, I'm satisfied that you're not going to pursue it, Attorney Gargas. I'm going to do this myself. I don't think it follows that Attorney Gargas is responsible for the fact that Mr. Manning didn't get a lawyer to pursue it and the case was dismissed as a result.
Was there anything that prevented Mr. Manning from doing his own investigation regarding the issue of competency?
No, I would think there wouldn't be. He subpoenaed many records in one of the Superior Court cases, and he could have subpoenaed medical records if he wanted to do that. I have no knowledge of whether he did or he didn't to determine the underlying facts behind the invocation of the health care proxy.
Mr. McBride, is there anything in the record with respect to how Mr. Gargas was appointed? As Judge Singh asked, was he off a list, or was he out there advertising his services as an expert in estates?
I would tell you that there's nothing in the record on that point. I think from what Mr. Manning has indicated in his affidavit and again in his oral argument today, it's always been the same. It's consistent with my understanding, which is that he wanted to pursue a claim against Aviv. They were in court. They said to him, if you will leave alone this, you'll give up the ghost on this Aviv claim, we'll let you be appointed. And he said no. So I think it follows that, Mr. Gargas has a nice reputation in the area. I think the judge knew who he was, and I'm assuming he was on a list to be appointed, but I don't have evidence of that, Judge Brennan.
The judge's decision references the court appointed.
Oh, yes, she definitely appointed Mr. Gargas. And how the name was surfaced, whether it came off of a list or somebody she knew, I mean, Judge Kaplan certainly knew Attorney Gargas from many years before her, so she could have either taken it. I think they have to take it off a list. That's my understanding, but I don't know that there's anything on record that shows that. Your Honor, the remaining counts, I think our brief basically speaks for itself, but the 3 counts, 2, 3, and 4, address fraud in different iterations, and I think Judge Liu has appropriately addressed each of them. And they were not argued specifically. Claim 2, fraudulent concealment, is not a cause of action in Massachusetts. It merely tolls the statute. the third claim, the count number 3 for fraudulent misrepresentation, and the fourth for fraud, all say the same thing, effectively with different verbiage, but I think Judge Liu has appropriately addressed them. And lastly, the issue of Chapter 93A, I also believe that under the case law in Massachusetts, I believe it is clear that this is not a case where 93A would apply. There's no evidence that Mr. Gargas was soliciting such business or held himself out as an expert, as there is in several of the cases, including the case that's cited by Mr. Manning, which is the Quinton versus Galvin, 64 Mass Appeal 792. In that case, the defendant was clearly holding himself out and advertised as a trustee or somebody who would act as this kind of fiduciary. No such thing happened here, and I believe, therefore, the case is barred under, it is not an appropriate claim for 93A.
The issue of quasi-judicial immunity, does that preclude the entire suit or certain
Your Honor, I argued that in the alternative in my motion to dismiss. Judge Liu didn't address it because he found that the matter was precluded on the fiduciary duty matter. But I do think there is case law that would support the fact that because he was appointed by the court, he had some quasi-judicial immunity. Thank you very much.
Thank you, counsel. Thank you both. The case is submitted. Our next and final case of the morning is another SORB matter, John Doe number 8579 versus Sex Offender Registry Board, and that's 2022 P25.
Good morning.
Counsel.
May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant John Doe. As you know, the Sex Offender Registry Board classified my client as a level 3 sex offender. Before I move on to my arguments, I just wanted to take a brief moment to acknowledge the fact that the facts in this case are tragic and that a young life was lost. So basically, I just didn't want to leave here without acknowledging that. Nonetheless, my client did serve 34 years for the crimes he committed in 1976. That was 47 years ago. And if you read the decision, there are many errors that the hearing examiner made within the decision, and one of them, I would argue, is erroneously finding or giving limited weight to Dr. Bard's report. Dr. Bard evaluated my client in 2019 and then again in 2021. He submitted 2 reports to the hearing examiner, and he testified at the classification hearing.
Why isn't it up to the hearing examiner to determine what weight to give to Dr. Bard's report?
I mean, it is up to the hearing examiner, but under the facts of this case, the fact that this expert examined my client twice, testified at the classification hearing, and submitted 2 reports, and he had a stack of papers that he looked through in terms of my client's past. And also, Dr. Bard was at the Mass Treatment Center in 2000 and also 2007, where he also evaluated my client for Section 9. And so he's very familiar with my client's background, my client's personality, and all of that. And so he determined that my client poses a low risk of reoffending. And there's many factors that he looked at to make that determination. One was the fact that my client was 16 years old when he committed the index crime. 47 years have passed, and today my client is 63 years old. He's presently living in a pretty stable and supportive environment. He has income, he has housing, he has no issues with drugs or alcohol at this point.
How about the 2016 and 2018 events, which seem to be important to Dr. Bard, that he credited it that, oh, your client was working in security? Why aren't, given his past,
Yeah.
Why aren't these facts highly disturbing?
Dr. Bard testified that these 2 convictions that my client had were relatively minor, and neither of them involved...
I'm talking about what was found on
Oh, the items that were found in the car. Yes, so he did believe my client in terms of that he had those items for security. It looks from your facial expression that you probably did not believe that. Nonetheless, my client was not convicted or charged with anything in connection to the items found in his car. And again, we're dealing with whether or not he poses a risk to sexually offend again. Is my client a great, awesome, excellent citizen? Maybe not all the time if you see his record, but in terms of him being at risk of reoffending, again, he was 16 years old when he committed these offenses, 1976. Many years have passed since then. He was at the Mass Treatment Center for 34 years. During that whole time, he was in sex offender treatment. And he's been out since 2013. That's almost a decade now, and he has not reoffended during those years. That's a significant amount of time. He did have alcohol issues back in the 70s, but he hasn't had an issue since the 70s. He's been really active with AA. I think in let's see if I can find the year. 2009, he received his 28-year medallion from AA. The hearing examiner did give risk elevating factor 9, some moderate. I think it was moderate. He applied it moderately, but under the facts of this case, I believe that was error because again, he hasn't had an issue since the 1970s. He's been involved with AA. He was the chairman of AA for like 14 years. So because of that, I believe that's an error as well.
So you mentioned that there was a factual error regarding the reference to the index offense being a rape.
Yeah, so my client was the only witness to the event. He was the only other person there. And he actually, the reason why he was arrested and convicted was because he turned himself into the police. And he pled guilty to what he's done. He's never indicated that he, did that.
In his own description, didn't he describe a rape?
He attempted to. Unfortunately. And again, the facts of this case is they're horrific, but he did attempt to. So that was his intention, but he was not.
There was physical evidence of a rape.
There was a report, so let's see if I can find his name. Dr. Henry issued a report in 2007 where Dr. Henry cited to a 1976 autopsy report. That report itself was not admitted into evidence. What was admitted into evidence in this case was the 2007 report that Dr. Henry authored. So my argument to you would be that that's second level hearsay, and because of that, not reliable. And again, my client was not charged with rape. My client was.
But the oral penile penetration, that's a rape.
So it was oral, I'm sorry, but the hearing examiner actually mentioned that there was also anal, penile to anal.
In the words of Doe, that was the attempt.
In the words of Doe, the attempt was anal, penile to anal.
And because it wasn't completed, it should not have been taken into consideration?
I think all his other actions were enough to be taken into consideration. I don't think that this one, there was sufficient evidence in the record for the hearing examiner to find anything reliable to find that my client raped the boy. And on top of that, I would argue that the hearing examiner erroneously applied high-risk factor 1, mental abnormality, finding that my client suffers from pedophilia. And again, that's based on Dr. Henry's report from 2007 and also a couple other CAB reports, 2008, 2009. The expert who examined my client in 2019 and 2021 found that my client, in fact, did not suffer from that. And there's nothing, there are some other reports actually in the record indicating that the phallometric assessment was done on my client, and that was from 2000, I think 1998, 99, and 2000, and he did not, there was no arousal. So 1998, 99, and 2000, the same report there was reports issued indicating that he did not suffer from pedophilia. So there's only one report in the record indicating that there was a reaction to the test that they conducted on him. And I would also say there was two other minor errors, I would say, in the hearing examiner's report, and that was in relationship to mitigating factor 33, home situation and support system. My client submitted evidence that he did have a pretty strong support system. He'd been with his husband since 2014, had been married to him since 2018. They live in an apartment where they've been really responsible and paying rent on time. His landlord actually submitted a letter of support indicating that they're good tenants and that they've been paying their rent on time. Also, two neighbors submitted a letter of support indicating that they each support each other. And two attorneys who my client has assisted in the past with helping with their clients. come back into society have also submitted letters of support. Because of that, I would say that this hearing examiner should have given that factor full weight. And lastly, I would argue that the application of high-risk factor 16, public place, but the hearing examiner should have given it, if applied, minimal, because my client at 16 was attempting to hide his behavior by going into a secluded area in the woods. And I would also say that there was not clear and convincing evidence that the board provided to argue that my client poses a high risk of reoffending. Again, the facts are, tragic, but it happened in 1976, 47 years ago. My client was 16 years old. Today, as we stand here today, he's 63 years old. All those years have passed without him reoffending. He's been out since 2013. He most definitely had the opportunity to and has not. He has no issues with drugs or alcohol at this point. He has a strong support system where he lives with his husband. He has housing, he has income. He was in sex offender treatment while he was at the Mass Treatment Center for 34 years. And again, the expert found that he poses a low risk of reoffending. And for these reasons, I would ask that this court either vacate the decision and lower the classification, remand it back to the board, or find that my client should not be required, his information should not be on the internet.
Thank you, counsel. We'll hear from the board.
If it pleases the court, David Chanai for the board. I have to say, when I woke up this morning at 4 o'clock to get here, I realized a time change had a bigger impact on me than I thought it would. This case is pretty straightforward. And I think when you look at the hearing examiner's handling of Dr. Bard's evidence, I think the hearing examiner did a good job of doing what the hearing examiner is supposed to do, which is look at the evidence and explain why, if they decide not to adopt that recommendation or the opinion of an expert, explain why they didn't. And I think the hearing examiner did a good job. For instance, factor one, there was evidence that this individual had pedophilia diagnosis in the past. Dr. Bard said that he no longer showed diagnostically that he still was suffering from that. The thing about pedophilia is if there's no evidence of interest in children for a 6-month period, which is what Dr. Bard testified to, then they're no longer considered at that point to be in the throes of pedophilia. But pedophilia, is my understanding, doesn't just go away. But the hearing examiner listened to what Dr. Bard said and said, look, there has been diagnosis of pedophilia in the past. Those are dated records, so I'm going to give minimal weight to factor one. Now, the hearing examiner, because there was a past diagnosis, had to consider factor one, but gave it minimal weight because of what Dr. Bard testified to. But at the same time, the hearing examiner pointed out the inconsistencies of Dr. Bard's testimony, especially the fact that Dr. Bard felt that the individual, his possession of Class E substance in 2017 didn't show any type of addiction issues because he believed that the medications were prescribed, even though a jury found this individual guilty of that possession beyond a reasonable doubt. You would think that he would have raised the issue that he had a prescription at the trial. So obviously that wasn't accurate. The second thing was, again, that whole incident of the car twice being filled with law enforcement, and serious law enforcement gear, DEA badges, batons, handcuffs, and then Dr. Bard saying, well, I read that, but he told me that he works for security. Now, I don't know any security firm that has you with DEA badges and DEA equipment and state police equipment. Then on top of that, Dr. Bard also, and I think this is where the major disagreement comes with, Dr. Bard started his analysis with the presumption that because he committed these sex offenses as a juvenile, that he had a low risk. Dr. Bard started with the low risk and then added things to lower that risk, and which is an improper analysis in this case. For instance, Dr. Bard said his treatment over 34 years really reduced his risk. My reading of the evidence was he didn't do well in sex offender treatment. He never completed a program in 34 years. He was constantly being removed from the program, stopping the program, restarting the program. And the other thing Dr. Bard says, during that time while he was incarcerated, he showed no sexual impulses, whereas there's evidence that he was stalking other inmates at the Mass Treatment Center for sexual favors. And he was actually described by the DOC records as being predatory in his behavior. So these are the reasons why the hearing examiner looked at this and said, I don't agree that this, with Dr. Bard's assessment, that he poses a low risk. And I think that that's well within the hearing examiner's discretionary authority, because the hearing examiner clearly explained the reasons why they didn't agree with Dr. Bard. As for the other complaints about the hearing examiner's decision with certain factors, I think I've addressed them all really well in my brief. Unless there's specific questions as to those factors, I would rely on my brief.
Could you remind me how the hearing examiner treated any presence or absence of the phallometric assessments?
My memory was that the hearing examiner used it in the sense that it really in the therapy session. And in fact, I think the hearing examiner talks about it in regards to that there was, I think it was a mass treatment report that said that he refuses to engage in the treatment that's required because of the findings of the PPG. I think that was the report. The hearing examiner noted that there was at least one PPG that came back that he did have deviant sexual arousal. MTC requested that he address those, and that they said that in the reports that he just wouldn't address it. In fact, I think at that point he was considered treatment resistant, is the phrase that they used. And they were focusing on the deviancy that was shown in that PPG.
So is this an example of where your hearing examiners tend to use PPG when it helps them, but decline to use it when it helps the petitioner? Well,
I would hate to frame it that way. I think there was one other incident I saw where the argument was that the PPG didn't show sexual arousal, and really what the PPG showed was that there was no arousal to anything, which I think the person who ran that PPG testing felt that that was an inadequate testing. I haven't seen a case specifically where the PPG gave a favorable rating on certain areas where the hearing examiner ignored it completely. But I think the realm here is that the PPG did come back, at least on one occasion, and it's not even so much that the hearing examiner relied on the PPG testing as much as relied on MTC's analysis that he refuses to address the issues that were raised in that PPG, which goes to Dr. Bard's credibility on that issue. Again, Dr. Bard testifying he has no deviant sexual arousal as evidenced by his behavior while he was in Mass Treatment Center, but again, he was shown to have predatory behavior, a sexualized version of predatory behavior. So again, going back to Dr. Bard's testimony, I think there was sufficient evidence for the hearing examiner to use her discretionary authority not to accept the opinion of Dr. Bard that this individual posed a low risk. In 34 years, if he had completed sex offender treatment, I think we'd be at a different base here. But he never completed treatment. He didn't get very far in treatment because he kept getting terminated or relieving treatment. He had hostility towards other group members. I mean, there were a number of problems this individual had while he was at Mass Treatment Center.
I think we have it, unless you have something else?
I never add more than I have to, Judge. You know that.
Thank you, Mr.
Thank you.
Chennai. Thank you both. The matter is submitted, and that concludes our hearing today. Our thanks to the court officers and the clerks for their role in making this hearing happen.